All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated.
Good morning.
So we are here on our case number 1CACR 180247, State of Arizona versus Candace Quijada. Before I begin, are any of the amici represented here in the? Are they present at all? Okay, thanks. Each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. We record these proceedings, so we'd be grateful to you if, when you approach the podium, you would give us your name, and the name of your client. We have studied the record at great length and have, of course, read your filings and the filings of others in the case. And we've also discussed the case among us in the past few days and also again this morning. So with that, you may proceed.
May it please the Court, my name is Elizabeth Brown, and I represent Candace Quijada. She is the petitioner appellant, and she is present in the courtroom in the front row today. This is a case about an unjust restitution order, and similar to the Lewis case, LEWUS, our court here did not give us a fair hearing at the sentencing level. The record will reflect that there were 3 hearings that were set for restitution at the sentencing level, and the first 2 hearings did not happen. They were continued due to errors on the state's part. When they came in for the 3rd hearing, which was on October 2nd, 2014, the court queried whether he could order the victim to come and be present because she was not present at the hearing, and the state told the court that she would not be present.
In other words, the prosecutor said she refused.
Either was unable or unwilling.
Okay.
Ms. Brown, can I ask you a couple
Yes.
questions about that? I can't find in the record where the defense issued a subpoena for the victim for the October 2nd hearing. Was that done?
I don't believe it was.
Did the state issue a subpoena for that October 2nd hearing?
I did not see that, and I was just asking the prosecutor about that earlier this week, because in his brief, he does attach the 2 subpoenas for the 2 prior hearings. So I have not seen that.
You have to issue a subpoena every time, or can you just order that they remain in full force and effect?
Assuming that it's in full force and effect, and according to the record, they did reach out to her the night before that October 2nd hearing. So she was aware of it.
The 2 times that they did issue subpoenas, did she attend either of those hearings?
Yes and no. She came on the first date, which was in May, and she appeared for 4 minutes of that hearing. At that hearing, my client was not notified of it, and her attorney had withdrawn. So they did not have notice of that hearing. The court took a break to see if they could call over the trial attorney, and at that time, the victim did leave. At the second hearing, I was not there, but the prosecutor, according to the October 2nd transcript, said she had some sort of breakdown, and she left before the hearing actually started.
In October?
He said that about the August hearing. So she
came to the August hearing, but then she was sick or something, to that effect.
Correct.
So she showed for May and August.
Yes, but was only present during 4 minutes of a hearing. The first hearing, where my client wasn't in attendance because she didn't have knowledge of the hearing. And at that hearing on October 2nd, it was approximately 19 minutes long. They argued back and forth of what they should do with this missing victim. Ultimately, the judge ordered the defense to file a legal brief on what this meant. And
On what meant?
the victim not appearing and whether he asked the question whether he should subpoena the victim and order her to appear.
He meaning
The judge, yes. And thereafter, the defense filed a brief and asked for a hearing. And still, there was no hearing. The judge simply jumped over and made the restitution decision based on the documents that the state had supplied.
Did your client, short of examining the victim, have any evidence to put on to contest valuation or the things that packet of information you had received at, I guess it's at the second hearing? Did your client have anything other than witness examination of the victim?
Not as far as I know. I was not the attorney of record at that time, and according to the record, I don't see anything. She was simply asking for a hearing. There was information that we obviously developed after the fact, so there was information that could have been developed, but that was only with the assistance of another victim.
The husband.
The ex-husband, yes.
And so we don't know. Your client was asking for a hearing. There was never a hearing, so it's unclear what case she would have mounted.
Correct.
I thought Ms. Capozzi, when she objected, both at the October 2nd hearing and in her memoranda, indicated that it would be very difficult for her to, since she couldn't discover evidence from the victim, that she wouldn't know what the victim was going to say until she actually.
And that's absolutely correct. But for our having the victim number 2 who gave information to us and gave information to the court, we wouldn't have known any of that information. That's correct.
Do you believe that that a criminal defendant has a right to subpoena a victim?
No. I do believe if the victim appears and testifies, there is a right to cross-examination.
Why? You say no. Is there a statute? Is there a rule? Is there a case that says that you cannot subpoena a victim?
Under the due process clause.
No, but I think under the Blackman case, there is the inference that one could. I think I was referring to under Chapter 40, the state has cited a statute where she doesn't need to be present at the sentencing and beyond hearings. So I think that's sort of where I was coming from on that.
So the victim didn't need to show for any of these hearings. Is that, I guess, as a matter of duty law?
I think she should have, and I think that the court could have and should have seen that as either a waiver of her claim or made and applied a negative inference to her lack of appearance.
Okay, so the evidentiary calculus, the presence or non-presence to testify would go towards whether or not the burden has been met to establish a restitution claim.
Yes.
But that there's no compulsory process of the victim.
That's my understanding.
And you're, and, go ahead.
Oh, no. This is yours. I'm talking too much.
No, you're not. In the basis for your cautious argument on the issue of a subpoena is the statute that says that a victim need not be present at the sentencing.
Yes, Your Honor.
But that doesn't say you can't subpoena the victim. That just says if the victim isn't there, the court can go on without the victim. Right?
Yes,
Isn't that
Your
what the
Honor.
statute
Yes,
says?
Your Honor. Yes.
So how do I'm at both sides, I believe, cited to that statute, and I'm a loss to see why that statute says you can't subpoena a victim.
Well, I would obviously
meaningful
concede
hearing.
to the fact that we could subpoena the victim. We need the victim to prove our case, to show our case. So if the court disagrees with that, I would be happy to concede to that.
So you're a criminal defense lawyer.
Yes.
How long have you been practicing?
In law for about 10 years.
Have you ever subpoenaed a witness, a victim, to testify at a restitution hearing?
I have not.
Okay.
You suggested that if, in any event, that if the victim does not appear and give testimony, that the court might draw a negative inference. What authority what cases, what other states have addressed this issue and come to that conclusion?
Not with the negative inference, but the case that the state, and I believe one of the amicus briefs, was a Delaware Supreme Court case where they did find that cross-examination was a right. With respect to the negative inference, it was a juvenile case out of this court. And I'm sorry, but maybe when I pause, I can find that for you. But
Is it in your brief?
it is,
Okay,
yes,
we'll
it
find-
is.
we'll find it there.
Yes, thank you. And so, as I was saying, because she never actually got that first hearing, we would ask the court to remand us back because, according to Fancher, due process is satisfied if she's given the opportunity to contest the information, present evidence, and to be heard, and she was not heard at that sentencing phase. Likewise, she was not heard at the PCR phase because the court will see that there were a number of hearings throughout 2016, 2017, and 2018. We've been fighting this for a very long time. And the result, of course, was to increase the restitution amount by $1,000. And so the court gave us evidentiary hearings in name only. They were not any of the issues that we had presented in our petition. He informed us before, during, and after that he was not going to consider the evidence or our filings or the testimony, and that he was limiting the scope of the hearing, of the evidentiary hearing, to just what property had been returned or had been recovered by law enforcement and then accepted and received by the victim. And so we would ask that the court consider her failure to cooperate, because the state, as the record shows, reached out to her over and over during the pendency of this case, not only to give her information, but to get information from her. And the orders that we have from the court are impossible to fulfill because we don't have any of the information. We don't know which bracelet is the $10,000 bracelet and which is the ring. So there's no way that that order can be fulfilled with the credit given to my client. So, yes.
Is there anything in the record before the PCR that to support the victim's late notice that all these costume jewelry items were really not costume jewelry?
I'm sorry, I don't understand the question.
The tennis bracelet really was a tennis bracelet. It wasn't a play.
That explains the inconsistencies? No, there's nothing in the record that explains that.
Or to support the notion that it really was a diamond tennis bracelet?
No, just sort of a wish list from the internet that she printed out. There was nothing that supported those inconsistent statements.
Nothing like that was ever recovered?
No.
Pawn shop? Or
No.
any evidence was offered to support that any of the defendants had any of these items?
No, and that's one of our problems with this case, is that she didn't show the existence of the property. Anyone can say anything, that if someone steals their car, by the way, there was $1 million in there. And so she hasn't shown the existence, and we can't, without the cross-examination, prove that negative. So she didn't prove that the property existed, although we do have evidence on the record that the husband says it didn't. And she didn't prove a nexus between the criminal event and the loss. So with respect to the, yes.
Not to get bogged down in minutia, but was she subpoenaed for the evidentiary hearing at the PCR stage?
The court,
When I say she.
the prosecutor, being cautious, asked for the court's permission at one point, and the court denied that motion.
Okay.
And that was late in the stage. I'm thinking 2017, 2018.
Is that being challenged?
No, Your Honor.
It's not clear that anyone knew where she was.
That's correct.
They had her email address, right?
That's correct. And I believe the testimony of law enforcement was that they actually went out looking for her and talked to the neighbors, and she doesn't live where she was purported to live before.
I wonder where the check's supposed to be sent.
I asked the same question.
Well, your client is paying some of this. Where is that money going?
She is paying, and I don't know. I have asked that question. I obviously don't have access to that.
So she's paying into the court or some fund.
Correct, to the clerk, and presumably that is distributed. And she has, she was originally sentenced to 24 months of probation, but based on the fact that she didn't have the principal balance paid off of the restitution, the court tagged on an additional 3 years. So it has been a severe punishment for Candace, and as soon as that probation period ends, when it turns into a criminal restitution order, they will tag on 10% interest, and at the current rate of $200, it can never be paid off. So this is a significant punishment for her.
On the issue of the security system,
Yes.
there's a causation, there's the issue of causation being the link. I'm also curious about how on the time frame, for how long a defendant should be liable to pay monthly security monitoring fees. What's the law on that?
I don't know, but I believe that the request was only for a year or a year and a half. And the installation amount, which could presumably be a windfall to the victim, was more expensive. It was approximately $1,200 of the restitution request.
And just so I'm clear, there's no dispute that it was actually purchased.
I don't think there's a dispute. There is a receipt for it. I don't know if that is her home, if that's a rental home.
She's not living there anymore.
She's not anymore, correct.
But the husband testified that he's the one who paid for it. It came out of his money.
That's correct.
And that he was not asking for restitution.
That's correct.
So how do you get around the Brady case that talks about the equanimity? How is this case different than Brady?
Well, the first thing is the time factor, and the time factor should be a motivator, or a lack of motivation is what it shows. In fact, is that she wasn't afraid, that she didn't need to regain her equanimity by immediately installing this security system. So I think that the time element is a factor in that she installed it 6 months later, and then a year after that started demanding the money, and wrote a note on the side, something about there had been some breach, some kind of break-in earlier that month. So we would argue that that's potentially some kind of intervening event, but we would only be able to speculate because we don't have her to cross-examine her. In addition to that, there wasn't a break-in. It wouldn't have stopped this crime from happening because they were invited into the home, and there isn't any reasonable future threat. So that's how I think that this case could be distinguished. Even if this court finds that an alarm system in general could be an economic loss, I don't think in this situation it should be considered an economic loss.
So you use the word reasonable, future harm. Who makes that assessment?
Well, we would need some testimony. I don't know, because in the first letter that she writes, the victim writes to the court, she said that the co-defendant, the man, was looking for pictures, but that comes from Brianna, who was the house sitter, who also was involved. She wasn't charged, but she sold jewelry at the exact same time. She gave a bracelet to Candace, and that was one of the bracelets that was pawned. And then suddenly in the letter after that, December 11th, so the first letter was to the court December 5th, and then December 11th, the victim writes a letter to the victim services director. And in that, she sort of lumps Candace in, but she's not specifically saying she's afraid, therefore I need this security. It's for punitive reasons. She wants these people locked up. She wants to know why they're walking the streets. And so if the court has no further questions, I'll reserve time. Thank you.
Thanks. Mr. Platt.
Good morning. Good morning, Your Honors. Charles Platt. I'm a deputy Yuma County attorney. I'm representing the state of Arizona in this case. I'm not representing the victim. Concerning the first issue that the court has posed for us to answer.
Mr. Pop,
Yes.
before you get to that, maybe I can just jump right to the part that we're struggling with, and that's Yuma County twice subpoenaed the victim to a restitution hearing, correct?
I believe so, Your Honor.
All right. So it seems to me that you believe a victim can be subpoenaed to a restitution hearing because you did it. Well, not you personally. I think it was Mr. Varela who did it, but Yuma County did.
Yes, Your Honor. It was it was Prosecutor Thomas Varela who subpoenaed the victim, and after the prosecution phase of the case, during the PCR phase, I was looking for subpoena authority in the victim rights legislation and in rules of criminal procedure. And I was thinking, certainly I'm going to find subpoena authority. And lo and behold, I didn't find any. So I asked the trial court, Judge Kenworthy, to give me authority to subpoena the victim. And he
Denied it.
He declined to do so. And in the last couple of days, I have noticed that this court, in Blackman, 1995 opinion, reserves for another day the issue of whether reserves for another day. We don't have to decide today, and it refers to an earlier case called Dean v. City Court of Tucson. It's and in that case, Dean says victims are not insulated from being required to appear and testify. Dean basically looks at that victims' rights legislation and notes that the legislation implies that a victim can be required to testify. And
Well, but Dean was for trial, wasn't it?
which one you're in?
Dean was
Dean-
for trial.
Yes, but well, these were no. I think it was a pre-trial hearing in Dean, and in Blackman, I think it was a pre-sentencing hearing. I think the defendant wanted to cross-examine the victim in Blackman, I believe, on the issue of mitigation, I believe.
So your position, at least as far as what your research showed, was that your colleagues' subpoenas were worthless.
No, Your Honor. I think if I was in front of the trial court right now, way back a couple years ago or so, I think I would be maybe still asking the trial court for permission to subpoena the victim, but I would be having a much stronger case for that. And the trial court probably would have granted it.
Why do you need affirmative permission to subpoena a victim rather than the inverse?
Well, because I saw a statute, a victim rights statute, which says that the victim has the right to refuse to attend. And that's what the victim was doing in this case. It's very express. The statute, that particular provision in that legislation is very express. And that's what this victim, that's the impression I had. I have not met this victim. I have not seen her. Our victim services chief was only able to contact her electronically. And once or twice she responded, I'm wanting this restitution, but I'm not going to substantiate. Well, I'm paraphrasing, but she was demanding the restitution. She was going to get a lawyer and fight us for it and everything else. But
So what do you see as the repercussions for not showing up and providing oral testimony under oath? We have a suggestion of a negative inference, just sort of the notion that it goes to whether or not the burden has been satisfied. What's the state's position on what it means if the victim doesn't show?
I think, Your Honor, it means that the trial court still has an obligation to try to order restitution to the extent the court has evidence, sufficient evidence, to order whatever restitution the court may be able to order without the testimony of the victim. I think the court has a duty to do that.
So it's like not an absolute waiver?
You know, Your Honor, I saw a dissenting judge in this court in one opinion a long time ago saying, I believe that a victim can waive. And I believe I cited that in...
By not showing up?
I believe so, Your Honor. A dissenting judge of this court in one of those opinions concerning, I think it was restitution, said a victim can waive. The rest of the court in that case didn't go that far. It was more or less the negative inference idea, I think. I'm not sure where that came from, but...
What do you think of that, a negative inference if a victim doesn't show? What does the state think of that?
I don't know whether I agree with that, Your Honor. In this case, I just do not know whether this victim was able to attend. I think she has medical issues, and I think she wanted the restitution that she claimed, but she just would not agree to come forward and help substantiate her claim.
Of course, if she were subpoenaed, she could have filed a motion to quash and said that under oath.
Correct, Your Honor, and I wish I had come to the realization that I came to a few days ago when I was rebriefing myself. And the realization I think that I came to a couple of days ago is that the state could have subpoenaed this victim.
The defense could have subpoenaed the victim.
Absolutely. The case law refers to a defendant trying to subpoena a victim, and I think the state could have done so too. When I was looking for authority to subpoena the victim, I didn't just see any distinct authority. I was surprised about that, and I asked the court for permission. And if I had known back then what I feel like I know now, I am pretty sure I could have convinced the trial court to grant me. I think I still would have asked the trial court for permission.
What do you know now?
Well, what I know now is based on Blackman, opinion of this court, 1995, refers to Dean, and I read Dean last night or the night before last, and Dean says that the victim rights legislation does not expressly say that a victim can be subpoenaed for I think it was some sort of a hearing. It wasn't a trial, but that the legislation impliedly contemplates that a victim is going to have to be attending various proceedings, and that there is a due process right. I believe it was a defendant was seeking to subpoena due process right, and there's no right that the victim can assert. That's what the case says. It says a right cannot be asserted that does not exist. That's exactly what Dean says.
Do you know, is it a published decision or is it a memo decision?
Dean, I think, is a published decision. Blackman is a published decision.
Okay.
I have the decision with me.
Don't speak when you're away from the microphone. We won't. You can walk away from the microphone. Just don't say anything.
I'm sorry.
It's just not recorded. That's the thing.
That's okay. You can keep it. I'll find it.
Okay, Dean. I've got Dean. 173 years long.
Your time is running, so I want to. So let's assume, for the sake of my next question, that you can issue a subpoena. The victim elects not to appear. What's the remedy in that situation?
Well, there's probably some sort of sanction for not appearing, but I don't think the state would want to pursue that, whatever sanction there may be against.
Okay, so we're not going to arrest the victim.
Right.
Okay.
We're not going to arrest her. I think the state is going to argue to the court that the victim is not has been subpoenaed, but is apparently waiving her right to substantiate this claim, or portions of it that require her testimony for substantiation. I think that's what I would say.
So, for example, in another case, if the victim had submitted medical bills, but then failed to appear, honor a subpoena, and show up at a restitution hearing, your position would be the court could still enter restitution for the medical bills.
Yes, sir. I think my position, the state's position is, I believe on that, is that to the extent that restitution can be ordered based on there's got to be some sort of reasonable factual basis. Documentation, reliable hearsay is available. There's a sentencing rule, pre-sentencing rule, and the word reliable is in there. As long as the hearsay is reliable and it's tied to the facts of the case, I think that restitution can be ordered. For example, in this case, the victim told Deputy Sheriff John Beer on November the 14th of 2012, she identified a few items of property. One of them is that tennis bracelet.
Well, a tennis bracelet, yeah.
A tennis bracelet. Well, it's the only one, and we have it. We recovered it. I think it's in a pawn shop. The way she described it with this filigree pattern, kind of an antique filigree pattern, she said that was her mother's bracelet, and it was worth $300. And then a year and a half later, she provides a page from a catalog saying, here's the ruby and diamond bracelet worth $10,800.
Okay, so on your theory of how we would address remedy, you would say that the only evidence in this record that's substantiated is, what was it, $6,000?
You know, Your Honor, I went through all 23 line items, and that was the figure that I came to, but I am not confident about all of those items. I found receipts, and I think that figure is based on receipts, but I'm not sure that is the figure that would survive a cross-examination.
Is that the test?
Your Honor?
Is that the test, or
The test is whether the evidence is reliable. Some of the documentation, I believe, is reliable. Some of it is not. For example, the victim talked about a leather item, I think a case for a cell phone maybe, and I think she talked about, and this is early in the case, and then she supplied receipts. So there's a nexus, there's a factual nexus between her interview with the deputy sheriff, the very first time she spoke, November the 14th of 2012. And then a year and a half later, we have receipts, and the dates look like they predated her discussion with the deputy. So I think there is some factual nexus between her first statement and maybe other statements. For example, the receipts for the home alarm system. I think there's some basis for a restitution order. I just don't think, I am thinking it's not the amount that I initially calculated.
You think it may be less than that?
It might be less.
what is the state's perspective on, let's say we recognize an express right to subpoena a victim to testify in a restitution hearing on the incentives or the disincentives of a victim to participate and seek restitution in the first place. What's the state's perspective on that?
I think the state doesn't represent the victim, but the state would have consultation with the victim.
But the statute says you can represent the victim's interest. In fact, you have the burden, right?
I saw a statute that says the state does not represent the victim, and that the victim can get an attorney if the victim wants and pursue a case.
Okay. Well, yeah, we can leave that to the side. But the state's, what is the state's? Does the state have any opinion on what that would mean if there was a compulsory process for victims that said, if you want restitution, you're going to have to come into court and and face the defendant possibly and answer questions to pursue restitution in the first place?
I don't know that a rule would need to be so emphatic. I think it could be that the state has the authority to, or either party has the authority to subpoena a victim if there is a dispute over the claim, the restitution claim of the victim. And the state would not be wanting, in this case, or I don't believe in any case, to visit any sanction upon a victim who did not comply with a subpoena. I think a subpoena and then not complying with it is a case for waiver to the extent that waiver is permissible.
Can we talk about the alarm system for a second?
Sure.
The husband testified that he paid for the alarm system and he didn't want restitution. So why is the alarm system still part of the restitution order?
You know, we brought a lot of attention to the court, the trial court. I don't think I didn't emphasize that. I think I missed that, Your Honor, the fact that the testimony that the husband said he paid for the alarm system. If I had
and to be fair, it's not. He says I was the only one making money, so it came out of my salary, and I don't want restitution.
I saw that she provided receipts for it. They're attached to that memorandum that I wrote. And if I'm not mistaken, I thought maybe I saw she was connected to those receipts rather than someone else, but I'm not certain. I didn't know that fact, that maybe the husband is the one, but anyway, did you?
Let me ask you, what happens when an insurance company has the right to restitution for medical bills, but doesn't want that? They paid it, but they don't want it. Does the victim still receive restitution?
Yes, Your Honor.
Do you see any parallel or similarity?
I think that I saw somewhere, Your Honor, that a restitution claim of a victim does not belong to the victim. I saw language like that in case law, I believe, from this court, and that the judge is required to order restitution. And I believe it involved an insurance company. I believe that case involved an insurance company that declined to seek the restitution. And it's required. It's a sentence. Restitution is supposed to bring home to the defendant a consequence of the criminal conduct.
So what happens if the victim says, there's an express waiver, I don't want restitution? Is the court still going to have to impose it?
I don't think that we would ask the court. We have a role. We don't represent the victim, but we would be arguing in front of the court and so on, and I don't think we would be pushing that at all, Your Honor.
Is that you don't think, or you don't when you're? Have you ever seen that?
I'm thinking about that. I'm thinking in hypothetical terms, and my belief would be that we would not.
Right. So let's not deal in hypotheticals. Have you ever seen that?
Well, that happens all the time, right? In pre-sentence reports, sentencing reports, we see victim
not seeking restitution.
Yeah. So would you seek it then?
We would not, unless there was some sort of independent evidence, and then we might bring to the attention of the judge that there's a requirement to order restitution for an economic loss if there's sufficient evidence. And
so if the victim doesn't leave their address and the money's paid into the court, it just sits there for the county to use, or who?
My understanding is that those payments that the defendant is paying are going somewhere. And we have sent a deputy sheriff to that location once or twice during the PCR proceeding. And but anyway, the state wanted to urge the court to consider announcing a in a case where a victim of a crime involving the home of the victim is experiencing emotional distress as a direct result of that crime, that the victim can receive restitution for purchasing an alarm system for the home and for purchasing the servicing of that system for a reasonable period of time. I think a reasonable period of time would be a few months or maybe even several months, and that would be a period of time that the victim would identify typically, ordinarily, in a restitution statement. I emphasize the word direct result. I see two standards. I see a modified but-for causation standard that this court announced in Guilliams, and it got it from a First Circuit, Federal Circuit case, Vaknin. And then I see Wilkinson. Wilkinson, it seems to me to be a direct causation theory. If direct causation, which is a Supreme Court of Arizona opinion, if direct causation is involved, we have a victim in this case who may be experiencing emotional distress on November the 14th of 2012, but she does not act on that stress until May 2nd of 2013, almost 6 months later. If the Supreme Court causation standard in Wilkinson applies, direct causation, theoretically, conceivably, some other factor in addition to besides the crime involving her home may have also motivated her to finally purchase the alarm system, maybe a report of a burglary in the neighborhood. And if that is the case, then under the Supreme Court of Arizona standard, she's out. Direct causation is the rule there.
Okay.
If a concurrent cause comes to play a role, then the original direct cause becomes an indirect cause, and we have no longer economic loss. We have what's called consequential damages.
Okay.
But if the Vaknin standard, the modified but cause, which this court, I think this court, adopted in Guilliams out of the First Circuit back in Massachusetts, if that is, then maybe she would have modified but for causation extends the causation a little bit, it seems like to me. I see a little bit of a difference between those two standards.
Okay, one more question before you go. What does the record tell us whether the victim continues to live at that address?
I don't know to what extent the record might tell us where she lives. I think the court record, the clerk of the court in Yuma.
I thought there was some comment during a hearing to the effect that the state had tried to reach her and had gone to the home and seen stacked newspapers as if no one lives there.
Right. Deputy Sheriff Raul Garcia was my case agent during this, and he sent a deputy or two out there, and on one occasion saw a bunch of delivered items and contacted a neighbor or two, and they thought that she was maybe in Phoenix, maybe in some sort of care facility.
Okay. Thank you. Any other questions? Thank you very much.
Thank you, Your Honor. I have nothing further to add unless there are questions for me.
I think we're good. Thank you to both of you for your briefing and for your thoughtful argument. We'll take the matter under advisement and we'll issue a decision in due course. Now we'll adjourn.